As a migrant in the UK, one of the biggest shock you will experience living in this country is that they can change the rules and you will not know. They won't send you a text message, an email, nothing, because they expect you to visit the government website. And the problem is you might not know what to look out for when you go to the government website. There are just so many links out there. In this video, I'm going to share with you one of the laws that they changed. They call it part suitability. It was changed on the 11th of November. So it has already taken effect. In fact, when you go online, you will see someone say that, "Thanks for sharing. I know someone denied ILR because of debt accrued from car parking, congestion charges, and CCJ." You might be wondering what is CCJ. See, in this video, I'm going to share with you some of the reasons they can deny your visa application, maybe entry into the UK, extension, ILR application, whatever it is. I'm going to share with you as it appears here. Is on the Statement of Changes in Immigration Rules, October 14th. I'm going to put the link. Go and read it. It's a 111-page document. But yeah, I just felt let me share the highlights, the parts that you really need to know about. If you're meeting for the first time, my name is Cynthia. I share information that will help your transition abroad to be as smooth as possible. I share information about settling, working, or studying in the UK. If you're interested in any of these, please subscribe to this channel and turn on your notification bell so that each time I drop a new video, you'll be amongst the first people to see that video. If you need support landing a visa sponsorship job, you need someone to optimize your CV, cover letter, or supporting information, then reach out to me. The link will be in the description as well as in the comments. If you need someone to guide you on how you can transition from care to a higher paying job, please just reach out to me. I will support you. And without wasting time, let's get into this video. I'm sure by now you have seen some of those comments online, people telling you that they were denied ILR because of one thing or the other. You might be wondering, where is this coming from? It's from this document called part suitability. Some of these rules have been there previously, but they change some things. I feel it's important you pay attention to some of these subtle things that many times we overlook. We should prepare ourselves for things like this if you're going to submit any visa application or extension. When they say part suitability, it says applies to most routes under the rules, see section 1. And if an applicant is refused under this part, they will not meet the suitability requirement for the route on which they are applying for. The only people that are exempted from this part suitability are people from these categories I'm about to show you here. You can see Appendix EU, people for family permits, asylum, Part 11. You saw all these people. They are the only people that will not be affected. If you're on a skilled worker visa, global talent visa, innovator founder visa, a dependent, whatever you are, or you want to apply for indefinite leave to remain, then you need to pay attention to all the things I'm going to share with you right here. The first ground for denial is an application for entry clearance or permission must be refused where the Secretary of State has personally directed that the applicant be excluded from the UK. For the Secretary of State to recognize you and say, no, deny this person, then I don't know what the person must have done. They said the applicant is the subject of an exclusion order. They said the applicant is subject of a deportation order or a decision to make a deportation order. There are cases like this that do happen when your asylum application has failed. Things like that could lead to this. Another one is non-conducive grounds. Application for entry clearance or permission must be refused where the applicant's presence in the UK is not conducive to the public good because of their conduct, character, and associations or other reasons, including convictions which do not fall within the criminality grounds. So careful of the people you hang out with. That's what I believe from this. Associations, that's one thing you have to pay attention to. The company you keep, you just have to be careful. They have this part exclusion from asylum or humanitarian protection grounds. Just go and read about it. I'm just going to concentrate on these other ones I feel that are very important aspects. Criminality grounds. An application for entry clearance or permission must be refused where the applicant they now explain, has been convicted of a criminal offense in the UK or overseas for which they have received a custodial sentence of 12 months or more, or is a persistent offender who shows a particular disregard for the law, or has committed a criminal offense or offenses which cause serious harm, even when you're entering the UK. So entry clearance, even if they have approved that visa, if they find you at the border and you're trying to come in and they find out that some of these things apply to you, they can actually tell the person, hey, no, we won't allow you to come in based on these grounds. Safeguarding grounds. An application for entry clearance under Appendix FM must be refused if the decision maker considers the applicant's parents or parents' partner poses a risk to the applicant. You might be innocent, you don't have any issues whatsoever, but they feel that your parents, your parents' partner is a risk to you, so they won't allow you to come in because they feel the person you're going to stay with has some issues. Involvement in a sham marriage or sham civil partnership grounds. It says here that an application for entry clearance or permission may be refused where the decision maker is satisfied that it is more likely than not that the applicant is or has been involved in a sham marriage or sham civil partnership, or they feel that the person is involved. You maybe did not apply at all, you're just in the UK, but they feel that your marriage is sham and it's not appropriate, so they can actually decide to refuse your visa. And another one is deception grounds. An application for entry clearance or permission must be refused where the decision maker is satisfied that the applicant used deception by making false representation or providing false documents or false information in relation to the applicant, whether or not relevant to the application, and also not disclosing relevant facts in relation to the application. Some people might have applied to, get into Canada and then they refuse their visa application. Once the UK asks you that question, please respond accordingly. Respond with the truth, because if you don't respond, that's what they call the 5 Eyes. Australia, New Zealand, US, UK, and Canada. They share immigration information. They will always find out. And once they find out that you are lying, it becomes a problem. That's why you always have to discuss with your immigration lawyer, the person that is filling your application. Be sincere with them. Review your document properly before you submit. When you go out to get your COS, just be sure that this is not something that is fake, because sometimes they take a correct COS number and give it to more than 20 people. This has led to a lot of people getting that ban, 10-year ban. I am not an immigration lawyer. Please consult someone if you are in doubt. And there's also the breach of immigration law grounds. I don't even need to read anything about this because we already know when you are breaching immigration laws. I've shared with you the hours you can do. They say 20 hours you can do in addition to your sponsorship. If they say that is what you can do, then stick to it. Don't go and do more than 20 hours. If you do more than 20 hours, they're expecting you to get another COS. I've shared it severally on my channel. I know that these laws keep changing. Go and check the latest information by the government. If they say as a student you should not do more than 20 hours, please do not do more than 20 hours. It has happened to some people who want to apply for a graduate visa. Some people get away with it, but now they are more critical about it. Then there's this option of overstaying. They are saying that an applicant will be treated as having breached immigration laws if age 18 or over, they overstayed their permission, unless an exception. There's an exception there. Go and check it out. Breach a condition attached to their permission unless entry clearance or further permission has been subsequently been granted in the knowledge of the breach. Illegal entry, used deception in relation to a previous application. These are things you can always check. But they said there are cases where they can disregard overstaying. A period of overstaying will be disregarded for the purpose where the person left the UK voluntarily, not at the expense or directly or indirectly of the Secretary of State, and the person overstayed for 90 days or less, where the overstaying began before 6th of April 2017, or the person overstayed for 30 days or less, where the overstaying began on or after 6th of April 2017. There are further information about overstaying. Listen to it and make sure you're not one of the people affected by failure to cooperate with the redocumentation, arrest and removal process, using a false identity, failed to report or absconded from immigration custody or bail, used multiple identities, participated in immigration related crime. Then when you want to extend your stay, permission including that extended under Section 3C of the Immigration Act 1971 may be cancelled where the person has failed to comply with the conditions of that permission. And there's also mandatory refusal grounds. Please go and check that out. Exception for overstayers. Please go and read it. I know why I don't want to read it, because I feel like it's very long. Your condition might be different. Failure to provide required information, where a person fails without reasonable excuse to comply with a reasonable requirement to attend an interview, provide information, provide biometrics, undergo a medical examination, provide medical report. Please consult your immigration lawyer. Now, this is the part that I feel is very important for you to pay attention to. Debt to the NHS grounds. And of recent, many people have been receiving these refusal as a result of NHS ground. Maybe they have a child in this country, the child doesn't have a visa, they believe that they will wait without giving the child a visa until the child is like 10 years or 7 years before they submit that application. So the problem is that your child has been attending the GP surgery, maybe if the child has a surgery or something like that, and then you don't know that they have kept that as a medical expense on you. You are indebted to the NHS. The NHS has started sending people invoices to say, hey, you owe us so amount, what's up, you need to pay. That is going on your record. That invoice is going on your record. You need to pay as a mother. You need to pay as a father. So if you submit an application for your child, then things like this actually pop up. I think that's the most common one I've been seeing online amongst people. People are not aware of this. You can always contact the NHS to find out whether you have any debt that you have accrued before you submit any application for a visa. I don't know. I'm just saying something like that. I think it could be, but I'm just sharing my own idea. Another thing is that they're saying an application for entry clearance or permission may be refused where a relevant NHS body has notified the Secretary of State that the applicant has failed to pay charges under relevant NHS regulations on charges to overseas visitors, and the outstanding charges have a total value of at least £500. So there is a figure to that. That's what they're after. Unpaid litigation cost grounds. An application for an entry clearance or permission may be refused where a person has failed to pay litigation costs awarded to the Home Office. Guys, many people have been confused whether it is mortgages and all those things. That's not what they're talking about when it comes to debt. I don't think they're considering private debt. They are considering those debt that has something to do with the government. So you have a business, you're meant to pay taxes, it could affect you. You need to pay those taxes. I feel it could. I didn't say it will surely affect you, but I feel if you want to reduce your chances of having all these issues going back and forth, and you have a company registered and everything, or even if you don't have a company registered, it's self-assessment, just pay up your debts to the government so that you have peace of mind, and that indefinitely leave to remain or whatever application you have will go smoothly. Unpaid litigation costs grounds. I think this is the reason why that person was talking about the person had car charges and all that. Remember, I got that online. I don't know how true it is, but I think that's what the person means. When the person has a CCJ, which is the county court judgment, and they tell you pay so amount, maybe you don't pay it or something like that. You know, all these things. When British people are not paying for their TV license, As a migrant, I would say you should follow everybody. That's my own opinion. I'm just saying. I just feel like there are some things you cannot afford. That is my personal opinion, guys. What's your personal opinion based on this? Because the things I see online is crazy. Purpose not covered by the immigration rules ground. An application for entry clearance or permission may be refused where a person is seeking to come to or stay in the UK for a purpose not covered by these rules. You're coming into the UK, but the reason why you can come into the UK is not included, and they feel that you have come in to do something. You've heard of cases where someone is on a visitor visa and is coming in, and then they see a CV, an application, something in your luggage. It's like, in the visitor visa, you're not meant to work. So why do you have a job application letter or cover letter and CV and other things in your luggage? I've heard of things like this. Medical grounds. Entry clearance or permission to enter must be refused where a medical inspector advises that for medical reasons it is undesirable to grant entry clearance or permission to enter unless the decision maker is satisfied that there are strong compassionate reasons for justifying the admission. They also have additional grounds for refusal or entry or cancellation of entry clearance or permission on arrival in the UK. Just go and read it. Consent for a child to travel grounds. A child might be refused permission to enter if they are not traveling with their parent or legal guardian, and if required to do so, the child's parent or legal guardian fails to provide the decision maker with written consent to the child seeking entry to the UK. You know, some people are already in the UK, they're just waiting. Once they get the sponsorship license, as a student, they're not allowed to bring their children. So once they get that COS, they now switch into that visa. They want to bring in their child. So they are telling you that you cannot just send your child in just like that. Written consent of their parents, both parents. So guys, I'm not an immigration advisor. Like I've always said, go and seek legal advice on the best way to bring your child so that you don't have issues whatsoever. Returning residence grounds. Custom breach grounds. We also have rough sleeping in the UK grounds. This is the one that blew my mind. I'm like, what is happening here? You're going through a lot as a migrant. If something goes wrong, they're saying do not rough sleep. Guys, it says permissions to stay may be refused where the decision maker is satisfied that a person has been rough sleeping in the UK and has repeatedly refused offers of suitable support and has engaged in persistent antisocial behavior. They're saying you don't have a right to have a mental breakdown in the UK. There are not many charities that can support you without having the government support. See, there might be charities out there. Reach out to someone to support you. Do what you can. Do not rough sleep in the UK. Please, I know that the changes in rules can be mentally draining. It could be really tough for people. Just avoid all these issues we are seeing. Even if you've done it in the past, they can cancel it. Even if you are in the UK, the one you have will be cancelled. Guys, have you seen cases where someone is given that letter instead of 60 days to leave? They're saying with immediate effect, leave the UK now. Please, if you have seen any situation like that, write it in the comment. We need to learn, because things are happening in the UK. Sometimes they don't give 60 days. They just tell you to leave, straight up leave, just like that. There are also cases where they said a person's entry clearance or permission may be cancelled where they are the dependent of another person whose permission is and has been cancelled. So if your main applicant has lost their license to stay in the UK or whatever it is, they can also cancel your own because you're dependent on that person. So we are talking about dependents of people on a skilled worker visa, global talent visa, even British citizenship. Like you're applying for family visa, I think it's included in this particular matter. Everybody has to be careful what they do. And when there is this withdrawal of sponsorship or endorsement grounds, they've listed those people who, if your sponsor has lost their license or has withdrawn their sponsorship, because there are cases where a sponsor will just withdraw their sponsorship. But that's the reason why you have to leave, because the purpose of you staying in the UK has come to an end. If the university feels you are wanting in one way or the other, maybe you don't show up for classes, they can withdraw it, and that is what can lead to the end of your sponsorship in the UK. Even with global talent visa, there are cases where the price has been withdrawn or something like that. The same thing can happen. Innovator founder visa, the same thing. Student does not start course or cease to study. I think that's the reason why sometimes they can decide no 60 days safe. So as you're showing up in school, just make sure you're taking your attendance. Some attendance is 75%. Some, they just send you random things every time through your email. So you all have to check your university email. That email they gave to you when you started, you need to check it from time to time. If you're not checking it, you might be found wanting. Worker does not start work or ceases their employment. So cases like this could happen. Sponsor loses license or transfer business. Transfer business is the most common one that has affected a lot of migrants. Seriously, this transfer option, there are sometimes when your company merges with that of another company, and because it has a new name, they're expecting your new company, I know it's a merge, it's still the same company, you're still doing the normal thing, but you are not aware that management has changed. You might still have the same line manager, but management has changed. Like top manager, they've changed the name of the company and everything. And suddenly the person just received, you have 60 days to leave the UK. And I'll be like, what is happening? I've been doing my job. But you were not aware that they have merged off, or another company has bought over your company. And because of that, they are telling you conditions where you need another sponsor license. The problem is getting a new sponsor license is a really big challenge right now. Some people, it's taking many weeks. I will say many weeks. I know it used to be like 8 weeks or so, but it's getting longer and longer for them to get that sorted. If they don't pay for the priority option so that they can get that COS, it becomes a problem for the company. So when you are trying to get that so that you can switch the person's employment, it leads to all these issues we have been having, where they are giving some people 60 days to leave the country or switch employer. It has happened before. In fact, there's one time it was happening a lot more often than it used to. Please pay attention to this so that you don't become you don't fall into any problem. Now, there is change of employer. There are conditions at which you can change. Absence from employment. There are conditions, change of job or lower salary rate. See, I'll just leave the link to this document. Go and read it for yourself. Digest it and understand it. If you have any questions, please write to your lawyer, an immigration lawyer. Ask them those questions. They will respond to you. I'll see you in my next video. Bye-bye.